Alex here with a legal nuts and bolts video on how lawyers win. So I've tried to do this video a few times, and what I was doing was bringing up a lot of examples, and it ballooned into way too long of a video. So I'm doing it all over again. And I'm not going to provide examples because I just can't let this video get out of control. In fact, I'm going to rely on people posting questions or comments, and based on those comments and questions that I get, I will go ahead and answer them to the best of my ability. So I'm sorry that I won't be providing very many examples in this video, but do keep in mind that I have provided plenty of examples in the My Docket series. So if you want to see more of, or even if you want to see like an actual trial, you can watch that, for example, in Our Nevada Judges, which is my other channel, which involves a trial. It's the state of Nevada versus Michael McDonald. So there's examples in other videos, there's examples in the My Docket series, but this video, I just can't do it or it just gets crazy long. Okay, next thing I want to mention is, even though this video is called How Attorneys Win, it is by no means limited to just attorneys. What I'm going to go over can really apply to anyone. Anyone who just pays attention to people, how people think, how people act, how people perceive the world. Anyone who really pays attention to that kind of stuff can figure this all out. And it can be a car salesman that does it. It can be a con artist. It can be, there's no limitation. This isn't just a thing that only attorneys can do. The next thing I wanted to mention is this video is not about how attorneys do their job generally. I have other videos that cover that. For example, win at all costs. For example, settlers versus litigators. For example, winged lawyers. This video is going to focus on how lawyers beat non-lawyers. And it's kind of a sister video to my most popular video on the channel, which is actually called How Abusers Win. So this video, How Attorneys Win, is going to be taking sort of the approach that I took in that video, which is to go down a list of sort of, tactics that you can expect if you're going up against a non-attorney, or sorry, if you are a non-attorney going up against an attorney. And the next thing I wanted to mention is, it's not like they have a playbook. It's not like somebody wrote a manual for lawyers on how to just stomp on or destroy non-attorneys. It's not even like there's a class or anything like that in their, law school. I think it's just something that they just figure out over time, especially for those attorneys that are going up against non-attorneys all the time. You're not going to see that so much with like criminal attorneys, whether it's a prosecutor or a defense attorney, because their system is like built to always have attorneys involved. If you have a litigant or a defendant who has no money to hire an attorney, they just get a free one. And there are other areas that involve like multi-million-dollar lawsuits, like punitive damage cases or medical malpractice cases or personal injury. There's hardly ever an attorney in that type of situation. A lot of those attorneys, if they find somebody who needs representation that's poor, they'll just do it on contingency because there's so much money at stake that it's worth it to them to take a risk on not getting paid if they lose. The area that you see a lot of non-attorneys is family law. And in Nevada, I think the percentage is around 60% of cases in front of the judges that have at least one party who is not represented. And that's, if you're in Nevada, if you're in family law, it's inevitable. You're going to go up against non-attorneys all the time. So the things that I'm going over in this video, I think it's just them paying attention. They notice that we make certain mistakes, that we do silly things, weird things, things that are not appropriate, not right, and they pay attention to that. And paying attention to it is a short step away from taking advantage of it. And taking advantage of it is an even shorter step away from actually inducing or baiting a non-attorney into making these kinds of mistakes. So hopefully people heed the advice in this video. It's mainly what not to do. It's not a what to do video, it's more of a what not to do video. And with that being said, I'm going to go ahead and jump into it. So the first thing is the attorneys focus on the strongest points in their case. Let's say there are 5 points in a case. Let's just throw a number out there. And we'll say 2 of them are favorable to the attorney, and we'll say 2 of them are not favorable at all. You could even say that if they are brought up, they'll just flat out lose. Like they could be fatal to the case. The attorney is not going to talk about all 5 issues. They're going to talk about the 2 issues that they are strongest, and they're going to spend the most amount of time on those particular areas. They're also going to identify the areas that do the most damage to you, and they're going to talk about those areas as well. So what does a non-attorney do? The non-attorney is a reactor. They react. They notice the lawyer is talking about these particular areas that are favorable to them, so I am going to spend all my time on trying to say none of that's true. They're trying to controvert everything that the attorney is focusing on that is favorable to their case. And then the attorney focuses on everything that is damaging to the non-attorney's case. And so the non-attorney thinks, I'm going to spend just as much time on that, on denying it all, saying it's not true. Well, what happens is the non-attorney has no idea that there are certain areas out there that are damaging to their opponent's case. And they may have also no idea out there that there are certain areas that are extremely beneficial to their own case. All they're doing is reacting to the lawyer. So they're not looking at their case, from a distance and identifying all of the different elements of the charges or the claims and the particular areas that they're strongest at and weakest at. They're just looking at what the lawyer's doing, and they're trying to controvert it or argue against it. And so non-attorneys will miss important areas of their case because they're just obsessed on trying to say anything that the attorney's saying isn't true. It's like the most common strategy a non-attorney has is deny everything. And you shouldn't do that because, it's good to do that to a certain extent. You want to controvert what isn't true, and you want to spend some time on all that stuff. But you also want to do just like what the attorney is doing. You want to identify the areas that are strongest to your case that they don't want to talk about. They're ignoring all that stuff. Focus on that because that is going to really benefit you. And all of the areas that are really damaging to their case, they don't want to talk about any of that. Identify those areas and bring them up. So the point of that one is pay attention to what they're not paying attention to. Don't make that mistake. The next one is bringing up old stuff. The judges rarely remember what's going on with the issue that's before them now. And I'm talking about reading the documentation and stuff like that. When it comes to remembering what happened at a previous hearing, they're even less focused on that. So I actually have a video dedicated to it. It's called "The Judge Does Not Remember You." And non-attorneys remember all of the things that were brought up that they feel are wrong, that are falsehoods. And a lot of times they cannot let them go. If a judge has made a decision and you haven't challenged it, there's nothing you can do. And what I mean by challenge, I don't mean bring it up again next time you go to court. I mean filing an appeal or a motion for reconsideration, which I am not a fan of. In fact, please watch my video, Motions for Reconsideration. I'm not a fan of those. They don't usually work, or they usually don't work. Anyway, if you challenge it within the boundaries that you're allowed to challenge it, and just move on. Don't keep bringing it up. I've seen a lot of videos, and I've talked to a lot of people who they go back into court on another issue, and all they want to do is talk about all of the falsehoods from the previous hearing, and they won't let that go. And so they're not paying attention to what is relevant now, and then they end up losing again because they're just so stuck on what happened in the past. Another video, I don't know if I talked about it yet, that you should watch is Overcoming Lies, Moving Forward. I have another bullet point here for bringing stuff up that is out of scope. And I have to be careful with this one because this is the one that I ended up trying to bring up 4 different examples and the video went out of control. So I'm not going to do that this time. I will just bring up one example for this one. There are certain boundaries to a judge's authority. And you could think of them as jurisdictional boundaries, which I'm not even going to talk about right now. And you could also think about, like I was talking about, the scope. And the example that I wanted to use that is very common is a motion for order to show cause, which is contempt motion. A person files a contempt motion. They want to, have the other person held in contempt of court. And what does that other person do? They show up in court and they start bringing up all kinds of stuff that the other person hasn't done. And they just assume, since the judge set a hearing, everything's on the table. I can talk about all these other things that they've done that are a violation of the court's order. Or I could try to modify child custody. Or I could try to collect money damages on this other thing. You can't do that. The court only has the power to consider what is before it. If you want to defend yourself on that particular issue, by all means, you can do that. If you want to bring up other stuff at that hearing, then you need to properly bring it before the court. You need to file your own particular motion. If it's something that's outside of the boundaries of that judge's jurisdiction, you may need to file another lawsuit, a separate lawsuit. I'm not going to go into any more examples or that one will go nuts, but that's a common mistake non-attorneys make. They think that the judge up on the bench who's wearing robes is a god who can do whatever they want, anytime they want. And so when they go into court, they think, I have all this other stuff I'm going to bring up. and they don't realize they're going to get shot down because the other side filed a motion and the judge is only allowed to consider the things that are in that particular motion. And so just don't make that mistake. If you want something to be addressed in court, you have to bring it to the court within the boundaries of the law, of the court rules. And if you do not do that, you just won't be allowed to talk about it. And the judge won't have any power to give you the relief that you're requesting. The next one is converting fairness, arguments of fairness, morality, right and wrong, general principles of right and wrong, into a legal argument or claim. You have to take these ideas of what you think is right, of what you subjectively feel is moral or ethical, and you have to find a way to turn it into a legal argument or into a legally cognizable claim. A lot of non-attorneys, they just want to wing it. They just want to go to court and talk, flap their gums. Here's all these things that are wrong. I need help. Please help me, judge. And you haven't really explained how that is a legal claim. Now, in small claims court, you're kind of allowed to do that. That's kind of the point. Small claims court, you just go in there and just talk. And the judge will take whatever it is you're saying and do their best to convert it into some kind of legal claim. And for the most part, small claims cases are very simple. Somebody hit my car, this guy punched me or broke my arm, and so there's not a whole lot to understanding that there are certain things the judge can do, give you money damages, stuff like that. But when people are in these complex formal proceedings like child custody or divorce actions, it's not always that simple. Sometimes there are really quirky situations, like when you have child support, you have two people that are working full-time. It's easy. It's a formula. You do the math and that's it. You get the amount. But sometimes it gets weird. Sometimes you'll have one person who's not working and they have their spouse that's supporting them. Sometimes you'll get a person who is underemployed. Sometimes you'll get a person who gets paid through a business. And the more complicated and weird the situation is, the more important it is that you need to go out there and do some research and figure out how to turn what you feel you are entitled to into an actual legal request, a legal argument. It matters, because when judges get confused or they don't have time to look into something, they just blow you off. That's just what they do. They're too busy. So if you have some idea in your head about what's fair and moral and right and ethical, don't go into court and just use that. Do some research and find out what the label is for that particular thing you are requesting. And go and do some research on what the elements are that you have to prove to win on that particular thing. And again, this isn't such a big deal if you're in court, like in small claims, but if you're in any kind of formal lawsuit, it is a big deal. I have a lot of videos where I talk about the wrong-headed approach of just going in and just arguing principles of fairness and right and wrong. In fact, the video title is Fairness versus the Law. The law is always going to win. And when you watch that video, it's not like I'm flippant about it. It's not like I'm saying, oh, well, if you're too dumb, you don't deserve to win. I actually explain it in a way that makes sense to people. In that video, Fairness versus the Law, I explain why you really can't rely on that kind of stuff, because a lot of these issues have more than one different perspective. And from both sides, it looks like both sides are fair or commonsensical. So there's more to it than what I'm saying. And so if you really want to know more about why not only is it not the right approach under the law, but it's not really under the approach under principles of logic, watch that video, Fairness versus the Law. You can also watch the video, The Machine. So I'm going to move on to the next one, which is not reading rules. And this actually ties into the first issue which I brought up, which was that litigants react. The thing about rules is it allows you to be proactive. When you research the rules, you know what you're supposed to do. You're not just responding. And again, this is what I talked about with the very first issue that I brought up. Most non-attorneys, they are in react mode. They don't do anything until something happens to them. So they just kind of idle. They don't do anything. They just wait around, and then they get a motion from the other party. The attorney files a motion. Uh-oh, they read it. I need to respond to this. The attorney files, I don't know, maybe they just got sued. They got the complaint. They got served. I need to respond to this. I need to file an answer. There are certain things in the law that are set in the rules that require you to do certain things at, by a certain date. And you can't just wait until until the attorney does something so that you can react to it. In fact, a lot of attorneys notice that non-attorneys don't do any reading of the rules, and they will exploit that. So let's take, for example, the case management statement or the settlement statement, or even the pretrial statement. That's probably the worst one to miss. The attorney knows that under the rules, these are due by a certain date. So they could file it early, 5, 6 days early, 10 days early. But what's going to happen if they do that? The non-attorney is going to get that. The non-attorney is going to get a case management statement. They're going to go, oh no, am I supposed to do this too? I better file one of these too. The non-attorney is going to get a settlement conference statement. The non-attorney is going to get a pretrial statement or a list of witnesses or the disclosure of evidence, the pretrial disclosures. And the non-attorney is going to go, oh no, I probably need to do this too. Well, they'll just do it the next day or 2 days from now, and they'll be okay because that's within the compliance of the rules. They reacted to that lawyer and they filed it on time. Well, some lawyers have figured this out, and what they do is they wait until the last possible second to file it. So a lawyer will go, oh, my opponent is a non-attorney. They didn't read the rules. So when is this case management statement due? On this exact day. They'll wait until 4:50 and they'll file it, or they'll serve you with it. Now, the non-attorney gets that, and they go, oh, crap, I've got to probably do this too, don't I? Oh, too late. You're late now. You've failed to comply with the deadline. Do not get into this mode where you are just reacting because they will take advantage of that. And it happens a lot, especially with the pretrial stuff. And then they'll object. You'll file it late, and they'll tell the court, look, they filed this list of witnesses late. They should be barred from bringing any witnesses. It happens with discovery too. The discovery will come up, and the attorney will start filing discovery instruments, requests for admissions, requests for production of documents, etc., etc. And the non-attorney will just respond to them, but they won't issue their own discovery. They won't understand, hey, I can do this too. I can send requests to them too. And anyway, these are just some common areas. When it comes to not reading the rules, you end up just being stuck in this react mode. You don't take any proactive steps. You're just trying to figure out how to respond to things. There are certain things that you need to do according to a schedule that you're not going to have time to react to, because the attorneys who have figured this out will wait until the last minute to file it on purpose, just because they know most non-attorneys forget to do this or have no clue that they even have to do it. So the next thing that I wanted to mention is understanding how appeals work. Now, this is a tricky one, but to file an appeal, you have to object to something in the lower court. They call it preserving the issue for appeal. Attorneys know this, so they will, even if they're not an appellate attorney, even if they themselves don't do appeals, they know that they have a job, and that job is to represent their client in not only the action that they're in right now, but also to preserve various different arguments for them on appeal, and just in case they, don't like the decision and they think that they can challenge it later on. Non-attorneys don't have any clue about this, and so they don't understand the importance of making objections or of preserving arguments for appeal. And then later on they lose their case, and then they want to file an appeal because they've lost. All of a sudden they want to do all this work, and it's too late. They didn't preserve any of those important arguments at the trial level, which is required with rare exceptions. And so it's a common mistake that non-attorneys make, is they don't understand the importance of preserving issues for appeal. They don't understand how the record works, how things are put into the record, how to submit evidence. And so they usually will figure this out after they've lost, and by then it's too late. You can't go back in time and make those objections now. The time for trial has come and gone. And so none of those issues were preserved, so that means they're waived on appeal. And so that's just another area, another mistake that non-attorneys make. The next one is asking the judge to give them what they want. Now, there's a fine line between this and asking the judge to agree with your legal argument. They seem like the same thing, but they're not. Attorneys understand the way the machinery works. The court takes in legal arguments and spits out legal conclusions. And so, in a way, they are requesting, they are asking the court for something, but it's different. They're making an assertion. They are presenting facts to the court. They are presenting legal arguments to the court. And they are asking the court to agree with them and side with them. The non-attorney, they don't do any of that. They don't present, some of them will present evidence. Some of them understand how it works. Hardly any of them present any legal arguments. Most non-attorneys don't even know what a legal argument is. And so what they end up doing is they end up saying, here's the story, here's what's going on, give me something. So they're not saying, here's my legal argument, I am the one that's right, so I should win. They're saying, help me, I don't know what's going on, I'm sad, I'm poor, I don't know what to do, and just come up with something. Just invent a solution that's favorable to me. And I hope that I made sense there, because sometimes people take that as I need to just be obnoxious and tell the judge what to do, but that's not really what I mean. But like I said, there was a fine line between those two things. There's a fine line between making a legal argument and asking the court to agree with you that you're right, and just asking the judge to do something for you because you're helpless. The next thing that I want to do, or the next one that I wanted to talk about, is attorneys making it seem like you have to convince them to win. They are not the judge. And yet, a lot of them know that the non-attorney on the other side is going to do everything in their power to convince them, the lawyer, which is silly to them because they have a client. Their loyalty is to that client. And so they're going to really just dig their heels in and not agree to whatever it is that you want, as long as it's something the client doesn't want to happen. So non-attorneys get sucked into this idea that if they can't convince the lawyer, they're not going to win their case. No. The lawyer is there for his own client. He's not the judge. You don't have to convince them at all. And in fact, sometimes people really, communicate a whole lot with that opponent lawyer, because it's like, they really get into this. All I have to do is convince that lawyer I'm the one that's right. Their own client is abusing all of this. They're abusing me. And once I show that lawyer that I'm the good guy, they'll turn on their own client. They'll betray their own client. It never happens, ever. It never, ever happens. The only time an attorney will typically go against their own client is when their own client files like a bar complaint against them or something like that. It doesn't happen because of their opponent. Much less because of their unrepresented opponent. So get rid of this notion that you need to convince that attorney that you're right. No, you just need to convince the judge that you're right. So I guess that is going to wrap up all of the issues that I wanted to bring up. I really do hope that this video is useful to people. I feel like it's not, because it doesn't have more examples, and I know people love examples. But, maybe somebody will have some questions. They can post them down in the comments below, or you can email them to admin@ournevadajudges.com, and I'll respond. And if it's a comment, I'll go ahead and respond publicly so other people can benefit from it as well. So thank you for watching, and I will see you guys next time.